Well, good afternoon, everyone, and welcome to our webinar on advanced care planning. I'm so happy to be with you, and we have a wonderful presentation for you today. With us is our esteemed panelists, and I'd like to introduce them and just give you a little information about each panelist. So today we have Carla Armstrong, who is our Director of Philanthropy at Gulfside Hospice and Gulfside Healthcare Services. Carla is the Director of Philanthropy and is a certified fundraising executive with more than 25 years of experience in nonprofit fundraising and business sales development. She's passionate about connecting with people who believe in the importance of hospice with a way to support it through donations. We also have Sarah Simkins here with us today, and Sarah has recently taken on a new role as the funeral director in charge of coastal cremations and funeral care of Lutz. She has been a part of Michels and Lundquist team since 2004, serving in families of the Pasco County area. Her role, in addition to many other volunteer roles throughout the community. Sarah feels that her profession that she chose fills her fulfillment in easing the grief and making that funeral arrangement process seamless for families she serves. John Butler is also on our panel today, and John Butler has served as Vice President at Michels and Lundquist Funeral Home and Cremation Services since 2013. With over a quarter of a century of experience in funeral service, John has worked as an apprentice, a funeral director, and a manager. John is currently a member of the Board of Directors at Gulfside Healthcare Services and is a member of the Rotary Club of Holiday. And we also have David Hook. Attorney David Hook was admitted to the Florida Bar in 2005 and joined the Hook Law Group, a law firm founded by his mother and fellow attorney, Joe Nelson Hook. David is a board certified in the practice of elder law since 2011, a member of the Florida State Guardianship Association Board of Directors since 2018, and past chair of the elder law section of the Florida Bar. And finally, we have Chaplain Charlie Lowry. Charlie is the Director of Caregiver Support Services at Gulfside Hospice and has been serving families in hospice since 2012. Following a career as a pastor and church consultant, and now Charlie's training, personal experience, and passion to help others uniquely qualifies him to serve as Director of Caregiver Services at Gulfside Hospice. Charlie coordinates all the work of caregiver support and bereavement services in those departments. So welcome very much, panelists. We're so excited to have you here. I know you're going to share a wealth of information with our attendees. And again, welcome to everyone who is attending our webinar. Now, just a reminder before we get started for everyone watching, you should see an option at the bottom of your screen that is for questions and answers. And if you have any questions you'd like to address, you can ask them there. We will either address them while the presentation is going on, or we'll cover it at the end of the presentation, and we will go through all of your questions that have been submitted. Also, if you have a question that you'd like answered privately, please feel free to call our team after the presentation, and we would be more than happy to help you. Once we wrap up, you will receive an email with a link where you can go back and watch the video later. Plus, at the end of this presentation, we'll be randomly picking two door prize winners out of a list of everyone who has signed up for our webinar today. So make sure to stay tuned for that. So let's start with a quick poll question so that we can get an idea of who is in our audience and what kind of information you're looking for. You should see a window pop up just now, and you'll be able to select the option that best describes you and that will help us very much so when we get started. So go ahead and just click on the choices there. All right, thank you very much. And so once again, we are here today to talk about the importance of advanced care planning and preparing for the future. Our panelists have some great information and resources for everyone who's watching. We have so much to cover, so let's get started now. So, Attorney David Hook, can you please give us an overview of what is an advance directive, a living will, a trust, and a power of attorney?
Sure. Thank you, Linda. Can you hear me okay? Okay. Advanced directives cover an umbrella of documents. Statute 765 mainly concerns healthcare directives, and Statute 709 covers powers of attorney, which were primarily financial directives. I like to split directives a little bit further than that, and that is whether or not the directive is going to affect you or become effective while you have capacity or after you lose capacity. Powers of attorney, for example, are effective as soon as you sign them. So that allows someone to be able to assist you as soon as the document is signed. Other healthcare surrogates and living wills, for example, only come into effect after you've lost capacity. Some people feel that they don't want to give up that authority, but you never do give up your authority as long as you have capacity. You make the decisions. You are directing someone else to act in your behalf. We have seen several cases, especially during the COVID times, where people have been in quarantine, for example. They still have capacity, they just don't have the ability to be able to go to the banks, to be able to get paperwork and sign paperwork. So you may want to think about giving someone the authority to be able to act at your direction while you still retain capacity. I often tell people that if you don't trust this person to act in your best interest while you have capacity, you may be choosing the wrong person to act when you don't have capacity. A living will is your end of life decisions. This tells your loved ones and your caregivers whether or not you want to have life prolonging procedures at end of life. It's usually split into what we call curative measures, meaning that they're actually going to make your condition better, and life prolonging procedures. So the thing is that you could be on a respirator and it could be curative, but then later become simply life prolonging. Wills, let me back up. Powers of attorney, as I mentioned, are only effective from the moment you sign them, and they're only effective until you pass away. And if they're durable powers of attorney, then they are still remain in effect even if you become incapacitated. But they cease to have any authority when you pass away. A will, your last will and testament, only comes into effect after you've passed away. And after the court has given the authority to the executor or personal representative that you've named in your will. Simply naming someone to be your personal representative in your will does not give them immediate authority as soon as you pass away. A lot of people think that, well, I was named in the will, so I'm going to start selling off the cars or whatever. They do not have authority until they've been given that authority by the probate court. A trust only controls the assets which are named or titled in the trust. It's purely an asset device in order to, it's effective when it's signed also. It can manage your assets while you're alive or after you've passed away, especially if your estate plan involves an elongated distribution. Maybe you don't want to have the children receive everything in a lump sum as soon as you pass away. The trust can distribute those assets over time, for example.
Thank you very much, David. There are so many very important documents that we have an option to be prepared, and they all serve very important purposes, as we've just heard, especially, excuse me, for each of your loved ones here that you're possibly taking care of who are participating on this call today. Charlie, could you please tell us a bit about the 5 Wishes booklet? What's it about and how can it help families?
Certainly. This is a copy of the 5 Wishes booklet. This is what it looks like. And it's a great booklet. to use as a discussion starter, to talk with your doctor, talk with primary caregiver, the family, about your own personal, emotional, and spiritual wishes as they relate to how you want to be treated if you become very ill or involved in an accident. This is a conversation that many people wait until a crisis occurs before they, talk about their values, preferences, and their wishes for healthcare. But there's so many things that are out of your control at that point. The 5 wishes can give you a way to control how you are going to be treated, if you get seriously ill. So the 5 wishes booklet is a guidebook of things that you need to talk about, document, and then get an opportunity to discuss those items with family and doctors and friends. Wish number 1, for instance, is about the person I want to make healthcare decisions for me if I can't do so for myself. If you become incapacitated, if you become just you're unable to speak, for whatever reason, you're unable to express your wishes, your healthcare surrogate or healthcare agent would be able to do that, but they have to be named. And that's one of the things that this wish number 1, covers. Wish number 2 is the kind of medical treatment I want or don't want if I am very ill and can't speak for myself. And so that's very important that other people know how you want to be treated. If you become very ill, whether or not to engage in CPR or other life-sustaining, measures, you need to make sure that you have that conversation ahead of time, because otherwise people are going to be making that decision for you, and they don't know exactly what you wanted them to do unless you've talked about it. So it's a real good guide to walk through that. Wish number 3 is how comfortable I want to be. How much pain do you want to be in? Do you want to be in no pain? Do you want to be sedated? Do you, a lot of those kinds of things. So that's something that you need to guide, you need to consider and talk about with those people. Wish number 4 is how I want people to treat me. And that's very good. It talks about your values and your, what you want and what you feel, and can be even some cultural things that you want taken into consideration. Wish number 5 is what I want my loved ones to know. If you want to make sure that you convey what you think and how you feel about your loved ones, this is an opportunity to get that written out, get that spelled out, kind of thing. And so that you communicate all that in case you're unable to, later on. So the 5 wishes really is meant to help you plan for the future. It can give you and your family peace of mind. The unexpected can happen to anybody at any age, at any time. And so having an advanced care plan is the only way to ensure that end-of-life decisions are based on your personal wishes, goals, values, and beliefs. See, I believe that end-of-life decisions really don't need to be made at the end of life. They need to be made ahead of time and talked about. Now is the time to begin the conversation. The time you spend planning is a gift for your loved ones in the future. And so it's best to go ahead now, begin planning, begin talking about it. And the 5 Wishes booklet is a good tool to use to help you have that discussion.
Thank you so much, Charlie. Really good information. And actually, we have copies of the 5 Wishes with us, and everyone who's registered here today will get a link in their email after this where you can request to have the 5 Wishes booklet mailed to you free of charge. So keep an eye out for that after this webinar. So having as much done as possible really takes some weight off family and friends when it comes to time for decisions to be made. Some people like to plan everything ahead of time, even funerals. So John, what kind of arrangements can be made ahead of time for ourselves to make sure that our family members don't have to worry about that later? And is that helpful?
Absolutely. First, let me say thank you for letting me be part of this panel. And kind of going back on a lot of what Chaplain Charlie said, he kind of answered a lot of this question before when he was talking, but documenting someone's wishes is really, it's a tremendous step. It's a hard step for anybody to take. It's one of those taboo topics that nobody wants to talk about. And it doesn't come easy to do. But it is the beginning of letting a family know, family and friends know what type of service you want, whether it's cremation, whether it's a burial, whether it's a funeral service, whether you want to be donated to science or have your ashes scattered out at sea. There's a lot of things that you could be doing once the time comes. But many families don't want to talk about this. Next step would be, writing it down, but then taking it to the next level is talk to a funeral home. And that being said, they have things written down. They can go through all the options with you. You may not know that there's an option of making your cremated remains into a diamond or shooting them off into space. There's a whole gamut of things that can be done when someone passes away. And that's why I say we talk to a funeral home, because they can present all the options and they can even go through the costs and everything with you. And then final step would be actually prepaying for these arrangements. And what that does is it tells the funeral home what you want, tells your family what you want. It also locks in the price for at today's cost rather than what it could be from this time 5 years from now or 10 years from now, or whenever the unfortunate time comes, because costs of goods and services are going up actually quite a bit lately. But putting wishes in your will, it's nice. Putting wishes and on paper is good, but I think David mentioned that your will isn't read right away. It's read after the services are taken care of. So having it done ahead of time and talking to a funeral home is ideal.
Yeah, I agree. Sometimes people are in such grief, it's hard to make those decisions. So having that done does take off a lot of stress. So thank you very much, John. Sarah, how about if we talk a little bit about timing? When should someone start getting all of these documents and arrangements in place? And is it ever too early?
No, Linda, I don't think it's ever too early to talk about these things. Piggybacking Johnny and Chaplain Charlie, it is a taboo topic that most people do not like to talk about, but I feel it's better to talk about it before there's an emergency and before something happens, when we're all of sound mind and can make this decision. It does let your family know exactly what you want before the services are needed. So I do think it is important.
Well, thank you. I agree with that as well. And, oftentimes people also want to plan ahead philanthropically, and they like to use their estates for charity or, other things. So Carla, what is a planned gift? What are some of the ways people can leave a donation to their favorite charity when they're gone?
Yeah, absolutely. So a planned gift is it's a donation, but it's one that you designate to happen after you've passed away. And there are a couple of different ways that is possible, but essentially it's exactly what it says, a gift that is planned, but for later, so after your lifetime. And because of that, it can sometimes allow someone to plan for a gift that's larger than they would have been able to make within their lifetime. So there are a couple of different ways that's one can plan for a gift. The easiest and simplest way is a little bit of what attorney David Hook mentioned is in your estate plans, in your last will and testament, you can name a bequest. It's a really popular and a fairly simple way to make a planned gift. It can be by designating a certain amount or a certain percentage of your entire estate that you can really choose to give to a nonprofit or a charity that can have a really lasting impact. Another way is with an IRA or a 401k by naming a charity as a beneficiary. And that could be either as the primary beneficiary or what they call a tertiary beneficiary, which is like a secondary beneficiary. So if the primary beneficiary, for whatever reason, is unable to accept that, then it would go to the secondary beneficiary. And that's a really easy way to also take retirement savings that maybe you didn't need within your lifetime and be able to have really good lasting impact with a charity that you care about. And then another way is similar to that IRA or 401k, which is a life insurance policy. A lot of people don't realize that you can name a charity as the beneficiary of a life insurance policy. In fact, some people actually will take out a small life insurance policy simply to be able to name a charity, their favorite charity, as the beneficiary of that. It's a really common and easy way to do that. You can also name multiple beneficiaries with a life insurance policy. So it's a great way to take care of family and the charity that you care about.
Well, thank you. That's wonderful. And I know that, Carla, you've got a lot of opportunities for people who have been affected by hospice to be able to donate to Gulfside as well. And it's nice to think about that, especially if it doesn't hit their financial situation now, and be able to pick a charity of choice that makes them feel good about. So thank you for sharing that. Also, just a reminder for everyone that's watching, if you have questions for our panel, you can use the Q&A feature and we will be sure to address those for you. So now let's talk about probate. David, what is probate? What does it cost? And would having a will in place avoid having to go through probate?
Muted me before. I figured you unmute. A will, as I was saying before, only comes into effect after you've passed away and the court has admitted it to probate. So a will itself does not avoid probate, but is the directions for the probate process. The probate process is essentially the acceptance of and validation of the will by the court, the appointment of your executor or personal representative to handle your final affairs, gathering up your assets, paying off your last creditors, last debts that you may have, and then distributing your estate amongst the beneficiaries that you've named in your will, which could be charities, family members, etc. The nice thing about a will is that you can have contingencies built into those gifts. You can say, for example, I'm leaving things to my spouse. However, if my spouse doesn't survive, then I want to split amongst my children, or I want it to go to this charity or that charity. Having beneficiaries named on your accounts, like Carla was saying, is a great way of avoiding probate. It goes directly to that person that you've named. However, there can also be issues. What happens if you've named, for example, your son to be the beneficiary of an account and he doesn't survive you? Is there a secondary, tertiary beneficiary named there, or is it going to fall back into your estate? So there can be some unintended consequences by just simply naming someone as a beneficiary. However, it does avoid probate. So what does probate cost? This is probably the biggest misconception that I have with people that I speak to. So often I hear things like people say, oh, well, the state takes 30%. That's not true in the state of Florida. The court costs for a probate range from $235 for a summary administration up to about $400 for a formal administration. Now, to that, you have to add, those are just the court costs. And to that, you're going to have to add a couple $100 for mailings, for publications in the newspaper, the executor's bond. You could have a couple $100 involved in there. The legal fees are negotiable. Always remember that. The legal fees are not set in stone. They are negotiable. And in our office, we set our legal fees based upon the complexity of the estate. It could be only one bank account that needs to be administered. It could take only a couple of hours, or it could be multiple pieces of land that need to be sold, or a business and beneficiaries far flung around the world. That's going to be much more expensive and more complex and more time consuming. So you need to speak to an attorney to talk over the complexities of your estate and what it's going to cost to handle the probate. But the probate fees are negotiable, and it is not as expensive as people believe. There's also a misunderstanding about estate taxes. Florida does not have any estate taxes other than the federal estate taxes. And the federal estate taxes are only on the amounts above $12,060,000. So a lot of people who are worried about estate taxes really have no reason to worry. So these are some things that you really need to think through, and don't be so constrained by misinformation as to what something's going to cost, because sometimes a will is the best way to administer your estate. For some people, especially if you have pieces of property in another state, a trust is a better way to go. But sit down with an attorney and discuss it.
Thank you, David, and thanks for clarifying so much of that. I mean, I think that dispelling the myths out there is so valuable for people listening today, so thank you. All right, Charlie, you and your team work one-on-one with caregivers, and you've experienced firsthand why it is so important to have those documents in place and have open communication with families for them to share their wishes. How helpful is it? How is it helpful for caregivers to have the appropriate documents in place and up to date?
Well, really, it's just critical for the patient, the caregiver, the medical team, and the family. Accurate, timely communication to all these groups of people is absolutely essential to have a positive outcome. Don't dare trust your memory to remember all the details. There are just too many things that you have to recall to trust your memory for it. The information needs to be kept either in a binder, everything together, or it can be on an electronic device, a phone, a laptop, or an iPad, so that it can be carried with you practically anywhere you go, because you never know when you're going to need it. And if there were emergency to come up, you've got to be able to have it, right there available. For instance, if you were to have to go to the hospital, you'd need to have your DNR, because they don't know for sure whether you've got it. They're going to ask you, do you have one? And you've got to remember, what it said. Or do you have a living will? What's your medication list? The name of your attending physician or the family physician, and how do you reach them? When was the last time the patient saw the doctor? When was the last time the patient was in the hospital? Do you have a healthcare surrogate form? Do you need that? Because they don't know whether or not they can talk with you. If the patient can't talk for themselves, they've got to get that information. But if they don't know for sure that you're the surrogate, that you have permission to speak for them, you're going to have a tough time. And so then giving the schedule of medications, what the patient took last, and when they're due for medications. You may need to be tracking blood pressure or their blood sugar, and you have something that will help them be able to diagnose the problem. There are just so many details that you just can't keep up with unless you have them all in one place. In addition, you need to have an emergency backup plan. For instance, if you, the caregiver, can't make it to the hospital or can't be at the doctor's office, whatever it is, somebody needs to be able to be there that can speak for that patient. And so there needs to be a backup to the surrogate that has that information. So if you have it in a binder, or you have it online, you have it on an electronic device, they can fill in, they can answer the questions, they can make sure that you're given the right medications and when, and they can, it helps with the doctors to be able to accurately diagnose what the problem is. And so it's just absolutely essential that these documents be there, so that at the drop of a hat, you've got them, you're ready, and everybody knows what your wishes are. Otherwise, it's maybe they get it right, maybe they don't.
Yes, absolutely. Thank you again. That's just really valuable information. So John, what should someone do with those documents once they're filled out?
Again, I'm going to piggyback off of what Chaplain said. They need to be in a secure place. These documents are very important because, only you right now know what's on them. But if you don't let somebody know where you've placed these documents, again, if it could be online, if they're on your cell phone, my cell phone only goes by my facial recognition. And if you place it in your Bible, or if you place it in a safety deposit box, whoever, you just don't know if the family's going to find it later on. So you need to have it accessible and have other people know how to get to it. So kind of a side note, as an example, what happened last evening, we had a family that called all the funeral homes in the whole area because they couldn't find the prearrangements for their loved one. So having accessible to more than just one person is really important. And I know I just mentioned safety deposit box, but that's really probably not the best place for it. And I'm sure David would let me know, agree with me that sometimes the safety deposit box is locked and you can't get to it unless you have a death certificate. So having this information ahead of time in a secure place, but where everybody knows where it's at is a good thing.
Wow, so important. And you actually answered a question we had earlier on when we were preparing for this, is that you can have electronic records of these? You can have electronic documents?
Our funeral home, we can provide you with an electronic document,
Okay.
just email it to you, and then it could be electronic, or we have access to it electronically and email it out where it needs to go.
Okay, thank you. That's good to know. Well, again, thank you very much. I've got a few questions left, and then we're going to take a look at what's been submitted for our questions and answers. So just a reminder, if you have a question, please make sure you send it to us and we'll grab that at the end of this presentation. Sarah, if I don't have an advance directive, who will make decisions on my behalf?
If you don't have an advance directive,
Right.
if you don't have an advance directive and you pass away and you're at a local funeral home, your funeral director is going to look for the closest legal next of kin. So the Florida statutes wants a spouse, a child, parents, brothers, sisters, anybody that's the closest blood relative. If there's no advance directive and no one wants to step forward, a friend can, but if they don't want that responsibility, then, and there's no prearrangements, then our county, Pasco County, and other counties too, don't they? Normally have like a human resources division that could step in and make arrangements for on your behalf. So I know for Pasco County, they step in if you qualify to have your body cremated and placed at the cemetery in Dade City. So if you don't have your prearrangements made, and we just had this situation last week or last month rather with a family. It was a lady, she had no family, but she had her prearrangements made with us. So we were able to step in and fulfill her wishes of having her body buried, even though she had no legal next of kin. So we were able to lay her body to rest, which is what she wanted. So it's just important to have everything written down.
It really is. That's so wonderful that you were able to do that. And again, so important to have everything done ahead of time. That, of course, that's why we're talking about this very important subject. So thank you, Sarah. So if you have something that's very important to you that you want to make sure is done with your estate, like a planned gift, planning ahead, getting those proper documents in place, we know that's so important. Carla, what are the benefits of making a planned gift, and can I make changes to my charitable bequest decisions later if I change my mind?
Yes. So I'm actually going to answer the second question first, because I think that's a common one. Can I change my mind later? That answer is yes, especially if it's made through a bequest or that IRA or 401k or that life insurance policy. You can simply update your will for a bequest gift, or you can update the beneficiaries of either your IRA, 401k, or life insurance policy. So changes are always possible, and they're at your discretion. Now, there are a lot of benefits to making a planned gift. I think the first is really giving control, and that's part of what I think this whole webinar is about. Is by documenting and planning, essentially you're retaining control over what it is that you want and creating the best possible path to ensuring that that will happen for you. So with a planned gift, you can decide who it goes to and how it's used and what kind of legacy you want to leave with that gift. What's the impact? Is there a particular program or a passion for you with that nonprofit or charity that you really want to see live on beyond your lifetime? That gift can be documented with them so that you can make sure that your wishes are known, and then they can have that ability to follow your wishes. Another thing is that some planned gifts come with tax breaks. It depends on the type of the gift that you're making. Some bequests can reduce federal estate taxes for heirs, but then these deductions aren't limited to cash. They can include assets like real estate and the IRAs and stock as well. There are other types of planned gifts that we haven't talked about because they tend to be a little bit more complicated, like charitable remainder trusts or charitable life estate trusts. So those are other options. But really, when it comes down to those financial implications, you're going to want to sit down with your financial advisor and your estate planning attorney to help best map out what those might look like for you and for your heirs and for the charities who benefit from your gifts.
Yes, thank you so much, Carla. So many different ways to give, and of course, giving to nonprofit organizations in this type of options that people have, they really make a difference for organizations. I know for Gulfside and many other organizations like hospices, when you get reimbursed one rate, it may actually cost a lot more than that daily rate. So being able to have those donations that come in from charitable families really makes a difference. So thank you for that information. All right, so let's look at some of the questions that have been submitted by those watching. We do have one question. Should you make sure your advance directive is on record with your hospital or doctor or church? So I'm thinking that might be a David question. Should it be on record with your hospital, doctor, or church?
Especially your most hospitals want to see your living will. That just seems to be a standard question. They are so focused on that when I think they really should be thinking about the healthcare surrogate or the healthcare power of attorney. But for some reason, they seem to be quite focused on living wills. Instead of being concerned with making these institutions have them, I strongly believe that they should be in the hands of the person that you're naming. That's the person that should have access to them, either a copy or the originals, because they're the ones who are going to need to utilize this. I don't know how many times I have had to fax over a power of attorney to a hospital just to have the patient move to another wing or another floor, and I have to refax them again. I would not rely on filing a power of attorney or a healthcare surrogate with a hospital and in hopes that they would be able to look it up when you're in there. Sharing it with your doctor or your church is a personal decision, but I would say give it to the person that you're asking to make these decisions to assist you. And I just want to piggyback on something that Carla said about control. So often people are hesitant to do these documents because they don't want to give up control. And that's false thinking. What you're doing is you are asserting control over your life while you have capacity, while you don't have capacity, and after you've passed away. You're not retaining any control by not making these decisions and not getting these documents.
Thank you, David. So true. We want to be able to control things now so that after we do pass away, no one else gets that control. So thank you again. I think this is also for you, David. If someone has a will or an advance directive document, but it was created in another state, is it still valid in Florida or other states?
Generally, yes. Most Florida statutes say that if the document, bigger document, that if the document was valid in the state in which it was created, then it is considered to be valid here in Florida. If you have moved to Florida and you're now a resident of Florida, I would strongly suggest that you have your documents reviewed by a Florida attorney to make sure they still meet your needs and your wishes. I have seen some wills, for example, that are completely valid, but it talks about burial wishes in upstate New York, and you may not have any family there anymore. So maybe it needs to be updated to be here where your loved ones are. So those are the types of things that you may want to take a look at. But a power of attorney that's done in Florida is going to be valid in other states. But once you move to that other state, please have it reviewed and make sure that it still conforms to what your wishes are.
Sorry. This one looks like it's for Charlie. And so how would our hospice team or another healthcare team, a medical team know if someone has an advanced directives, and how will they know where they are?
Well, that's a good question, and it's very important that that be communicated. If they're coming on to hospice, our team will usually ask about those medical forms and those directives, and we try to gather them or help them gather them, figure out where they are, who has them, that kind of thing, so that we do have an accurate copy. If one cannot be found, they can easily be updated. Create new documents, and the old ones just revoke those. And so that's not a hard thing to do. It's just something that we need to make sure we have accurate documents. But it is very important. If it's like a DNR or something of that nature, it's recommended that you post a copy of that on your refrigerator, along with the healthcare surrogate form and anything else, the living will, posted right there, so that if EMS comes in and is going to take you to the hospital, they're trained to look on your refrigerator. And if they see that you have a DNR, then that instructs them how they have to treat you, kind of thing. And you take that with you to the emergency room at the hospital. When you get to the hospital, even though you've been there before, every time I took my folks to the emergency room, every time they ask, do you have a DNR and what are your wishes, kind of thing. And so they're going to ask, even if you have one and it's in their system, supposedly, they're going to ask over again. And so it's vital that you have that ready and you take that with you. That's why I recommend, having multiple copies. Everybody that's involved, the healthcare surrogate, the family member, your attending physician, everybody needs to have a copy of that, so that there's no question as to whether or not those documents are there, so that you have that, you can show it to them. Because if you don't have the healthcare surrogate form and they're trying to do things, they don't know whether or not you really have the right to make the decisions. And so it pays to have that information right there handy, because it's going to be asked, and you don't want to be making the decisions if you don't have the power to make those decisions, because that can cause all kinds of problems with family and stuff later on. So always make sure you have those documents ready, available, multiple copies. Everybody have a copy of it, because it's not something you want to keep kept a secret. It's something everybody needs to know about.
Very true. I had a question at one point, and I know that this would be a good answer by John and Sarah. I know that family members that have filled out 5 wishes, there's an area on about their service, like their funeral or their memorial service. There's the opportunity to even list psalms or hymns or songs. Do you find that people have that pre-done, or is that some helpful when you have those on the 5 wishes for your team?
It is helpful, but it also puts people in the mindset that they filled it out, everything's all done. And in reality, it's not. They need to document it and then tell somebody. Need to document it and go talk to a funeral director. So it is awesome that they get that done, because it's a big step. Like I said in the beginning, it's a huge step, but passing it on to other people is even better.
Makes sense. Thank you. Okay, we got a couple more. This looks like it would be for David. When does a living will or a power of attorney go into effect? And why do I need a power of attorney if I still have capacity and can make my own decisions now?
A living will only comes into effect at the end of life. It's triggered by what's known as an incapacity to make a decision or make your wishes known during a time when there's no reasonable medical chance of recovery. So it's truly an end of life situation. Why would you want a power of attorney if you still have capacity to make a decision? I get that a lot. I was in the military. You are not deployable unless you have a power of attorney in the Army, because you could be in a foreign theater and there could be an issue at home dealing with rent. Your wife gets in a car accident, different things happen. And you need to, and they're not going to let you fly home to take care of those situations. Also, when I moved here to Newport Richey, my mother was already living here and she had my power of attorney after I got out of the military. She was my agent under the power of attorney. When I went to purchase my house here in Newport Richey, I was currently living in Miami. I came up, I saw the house, but the whole negotiation, going back and filing the offer, counter offer, even the closing documents were all able to be done by my mother here in Newport Richey while I was in Miami. Had nothing to do with my capacity, having to do with me being 5 hours away and being very inconvenient to travel back and forth, or having to overnight those documents back and forth all the time. So there are going to be and we just went through a year and a half, 2 years of COVID, where people were, sometimes they were sick, but sometimes they weren't sick. They just had tested positive and they were quarantined. You may need to have somebody be able to act on your behalf. So they act at your direction. At no time is your agent under the power of attorney your boss. They work for you. You're the owner, they're the manager. You're instructing them what to do. Now, if you can't give them instructions, then they do what they think you would want them to do. I also think that it's very similar to having a key to your neighbor's house, sharing keys with a neighbor, with a trusted neighbor. In case they're not unable to get home, they can give you a call and say, hey, can you let the dog out? Could you, with that key, go into their house while they're gone? Sure, but they trust you not to breach that trust. However, if you saw smoke coming out of the window or you saw water pouring out of the door and you couldn't reach them, would you inquire as to where the water's coming from? I would expect my neighbor to do that. If they couldn't reach me, I would expect them to open the door and go in and find out what it is. It doesn't give them the right. It gives them the ability, yes, to go rummaging through my drawers, but that would be a breach of that duty. And if you do that with a power of attorney and the person accesses your bank accounts and takes money, that's fraud, that's theft, that's embezzlement. Depending on exactly what they did, it's a crime. There's no doubt about it. Just because they had the ability to do it does not give them the right to do that. So just giving someone the authority to be able to do this does not mean that you are giving up your own control. You're dictating who this is going to be. If you don't do it while you have capacity, you can't do it after you've lost capacity. So if you don't do it now, while you have capacity, when are you going to do it? When are you going to do it? And if you don't, John and Sarah answered the question of who's going to make your funeral arrangements after you pass away. But if you don't have these documents in place and you've lost capacity, and there's no one with the authority to make the decisions, it doesn't automatically go to your children while you're alive or your spouse. Certainly financial decisions don't. And so you may need to involve the court system. Somebody may have to petition for guardianship on your behalf. This is going to be extremely expensive. And the control is not even in the guardian's hand. The guardian is just an agent of the court. So you're asking the judge now to make these decisions. So if you want to retain control, assert the control and make these documents and put your wishes down on paper and decide who you want to assist you while you have capacity and in the event that you lose capacity.
A resounding theme, do not wait, do it today, do it soon, do it now. So thank you, David. All right, we have one more question, and I think Charlie and possibly David or anyone else, please feel free to chime in. So someone's been appointed a healthcare agent. I guess that would still be maybe a family member or power of attorney for healthcare or a healthcare surrogate. How should that person plan what are his or her responsibilities, and are there any other resources? I know that Charlie, you probably have some other resources too.
Yeah, every situation is different depending on the status of the patient and your own personal set of circumstances. And so, that's why it requires getting some help really to figure out, all those questions. If you're presently serving as a caregiver and you don't have a plan, you should contact us at Gulfside Caregiver Support Services right away, so that we can help you begin to gather the resources you're going to need in order to meet the demands of being a caregiver, because they come, all those questions, they come out of the woodwork, and you're just going, wow, I'm overwhelmed, is what we hear constantly, by making those, just because they didn't expect to have to make all these choices all of a sudden. If you're not presently serving as a caregiver, but think you might be a caregiver in the future, then you need to contact Gulfside right away, because we can help you get this plan in action, get it set up ahead of time where it's an easy transition, to make, and we can give you the resources, for that. Now, if you're just wanting to just do it on your own, I don't recommend it. There's just so many details, so many things that can go wrong. And it's just a lot of stuff to sort through to make sure you get it all together. But if you do want to try to do it yourself, there are some resources out there. One of the resources that's out there is a really good resource by AARP. It's called this Prepare to Care booklet. It's a 35-page booklet. It's very in-depth, but it asks all the questions you need to know, stuff, gathering the information together and that kind of thing. We make these available to our caregivers in hospice. AARP has sent us the link where we can print them off. We have them here at our office to give out to help people begin doing all the planning. Then there's another planning guide that we use called Advanced Care Planning. This is a guide to understanding the advanced directives, and it breaks down every one of the directives and what information you need to have and why are they asking this, why are they asking that. And so we can help you plan out and begin having that conversation along with the 5 wishes, so that you make sure everything is covered. We've got funeral arrangement forms and stuff so that you can discuss that, and we can make recommendations as far as which funeral home and that kind of thing. There's a number of them in our area, and we just try to make sure that you're matched up with the right people, and you go and talk and you get all this information together and put it all in one place. You document it, you get it notarized if it requires it. You involve an attorney if you need to, but the biggest part is getting it done ahead of time so that you're not scrambling at the last minute trying to rush together, because it's a lot of information. And so the further in advance you can do it, the better off you're going to be. You take a load off of everybody's shoulders. You feel better about it. You have peace of mind in knowing it's taken care of. We got this thing, and then we offer support for caregivers in the form of support groups. We have a couple of support groups that meet regularly every week, and you can join a support group by just letting us know. We'll get the email, we send you an invite, and you can come in and talk with other caregivers and ask questions of them. You see what they're struggling with, what you're struggling with, and it's a real good support system to begin to build. And we talk about all the various different things that you're going to need and you're facing. So we have a tremendous program with tremendous staff. And then we have resources like John and Sarah, like David, that we can refer people to. And then if you're interested, Carla's always there to help. As far as what do we need to do to make our memory last for a lifetime, kind of thing. And so there's just all kinds of opportunities. But you don't need to wait. You need to get in touch with us now.
Thank you, Charlie, and thank you for sharing those resources. And really, this team here is here to help each of you here today. They have a wealth of knowledge. They're so compassionate. They're, they've got resources, and give us a call, give any one of them a call anytime. And I hope that this has been valuable for you. And again, to our panelists, thank you so much. We just have a few more minutes, but if you still have questions that you need answered, we are ready to help. don't hesitate to send them our way. Also, please remember, you're going to get a link to the 5 wishes. So if you'd like a copy of that, that will come in an email for you to have. And then after we wrap up, you'll also have the contact of our panelists and the link to watch the webinar again. And again, if you want extra copies of 5 wishes, just let us know. Today's video will also be posted on our website at gulfside.org/webinars. And you can go back and watch it later. You could send it to someone, anyone that might even be interested. But before we completely finish, let's select our door prize winners. We've entered all of your names into the wheel, and we're going to randomly pick 2 names. And after we wrap up, our public relations team, who helped us put this wonderful webinar on today, will contact the winners. So let's get started and pick a name. So our first winner is Mary Ann D. Congratulations. You have won a gift card. And our next winner is Joe N. Congratulations, Joe. You are our second winner who will also receive a gift card. So congratulations to all of you. Again, thank you for attending. Our team is available to any of you, each of you at any time. Just give us a call. Thank you for joining us today. Thank you again, panelists, and have a wonderful afternoon.